Comfortable?
Yes, I am.
right.
Thank you for asking.
Okay. You come from my hometown, Mthatha?
Yes, CJ.
You were born there?
I was born and bred there, and
you
also worked a little bit at Tata Magistrates Court as a state prosecutor.
Yes. And you also obtained your legal qualifications there?
Correct, CJ.
At the University of Transkei?
Yes.
A BURIS and LLB?
That's correct, CJ.
Okay. You were not in one of my law classes, were you?
CJ, I did not want to say this, but I was one
Which
of your
one?
students in the interpretation of statutes.
Oh my goodness. I hope I did not suck as a teacher.
No,
did you enjoy my classes? Be
No,
careful
you
how you
didn't.
answer that question.
You didn't, CJ, because I passed that course.
All right. I was very young then. As you've already mentioned, you worked for a spell as a prosecutor in the magistrates court. That was just over 4 years.
Just over 4 years, CJ.
Then you decided to move to KZN.
Then I decided to do pupillage at what was then known as the Transkei Bar.
Or you did it there?
I did it there, yes,
all right.
CJ.
Was your...
My mentor...
They are not called masters now. Your mentor...
My mentor was the late Advocate Nceba Dukada.
So you started practicing as an advocate at the Durban Bar in 2005?
That's correct, CJ.
Okay, so how many years have you been counsel?
CJ, it's about 19 years
about
now.
19 years, it's a long time. And you have done many things in the interim. You have acted as a magistrate for 6 months at the regional court in Durban.
That's correct, CJ.
You have sat in, well, you've been a panel member in a few boards, including the Financial Services Tribunal and the Financial Intelligence Center Appeal Board.
Yes, CJ.
And for how long? From 21 until I see your stints in those ones ended just at the end of September.
At the end of September, yes, CJ.
What exactly did you do there as a panelist?
Well, briefly, CJ, we dealt with the applications for reconsideration of decisions that would be taken by the decision makers, and that would be your ombuds, that would be the financial service providers like the banks and the insurance companies, and we also dealt with the appeals.
So when you started acting, you had some quasi-judicial skills, acting as a judge, I mean.
Well, if my memory serves me well, CJ, the appointment to the tribunal, it came after I had started acting. I started acting in 2018.
Yes. You acted both in the Eastern Cape and in KwaZulu-Natal.
That is correct, CJ.
When and for how long in each division?
Well, I do not know. I have not separated my acting stints, CJ.
Okay, well, I'll help you. Your CV says you acted in KwaZulu-Natal for a session. Well, I don't know if it was a full session in 2018, between November and December.
CJ, are you looking at my schedule of acting stints?
Oh, you have it?
I have a schedule.
All right,
of acting stints.
Can you help me figure that out? I'm trying to determine exactly how long it is that you have acted.
Yes, let me find it.
I counted just over 10 months. I'm not sure if it's correct.
It should be Annexure C.
It's
page 39.
I have it at page 23 of
your bundle.
Of the bundle, yeah.
Yes. So Basically, CJ, when I submitted this application, I had 42 weeks of acting. The very first acting stint was in Durban for 5 weeks. It was from the 12th of November to 14th December 2018.
All right.
And then I went to Pietermaritzburg. That was 2019, June 2019. So what I've done, CJ, I've tried to avail myself for acting each year, except for 2023. And then recently at Durban High Court for a full term, which started on 15 April until 21 June. But then after I had submitted my application, I had about 2 weeks of finalizing my part head. I have a criminal part head. So I think I have about 44 weeks of acting.
All right. And what kind of cases did you sit in during this stint? Was it the whole range?
The whole range, CJ, but mostly in the civil court and in motion court. I've done civil trials, I've done opposed applications, I've conducted motion court proceedings, I have sat in the criminal court, I've sat in civil appeals, criminal appeals, I have sat with the full bench. I have done reviews, in-chamber reviews, the whole works.
All right. Well, what kind of criminal work, appeals or trials?
Criminal appeals and trials, CJ.
How many trials?
I have I've completed 2 criminal trials. I am now busy with the 3rd criminal trial, which is the one part head that is reflected in my application.
All right. And the 3 judgments you listed as reserved from May, what is their status?
They have all been handed down, CJ.
All right.
I have the dates on which they were handed down. I don't know if CJ would want me to...
No, that's not necessary. You would still fall within the 6 months.
Yes.
How many judgments did you get to write during your acting stints?
I've counted, CJ, about 50 judgments since I started acting. 50 since 2018.
Any of them reported?
No, CJ.
No. What kind of a practice have you been running? What kind of work do you do?
Basically, CJ, my practice survives on government work. I get more instructions from the state attorney, and I have a few private clients. Recently, since I've taken silk, I've been doing a lot of arbitrations. I've chaired arbitrations as well. But with the general state attorney work, I do a lot of labor court matters, land court matters, a lot of civil trials and motion court appearances. I have not been fortunate enough to receive instructions to attend to commercial matters. In my years of practice, I've only had the opportunity of being led by senior counsel on 2 tax matters. That was right at the beginning of my career. So that's basically the nature of my practice, CJ.
Yes. You are senior counsel?
Yes, I am.
Since
CJ.
when?
Since 2021. It's my 4th year now as senior counsel.
You list, well, and the professional bodies as well vouch for you. You've been involved in a number of mentorship programs. You mentor young practitioners at the bar.
That's correct, CJ.
And you do a significant amount of pro bono work as well?
I would say significant in the sense that, CJ, it's not the one that is registered on the pro bono register of advocates, but it's the kind of pro bono work that I would get when I visit home at Mtata. My mom would have her friends lined up to give me or for me to give to attend to their problems. I've had the benefit of assisting ladies who were selling chickens at on the side of the road at near Mandela Park at Mtata, where their chickens, their livestock was taken by the metropolis because they did not have permits to trade. So those are the kind of work, pro bono work that I do. It's not the kind that is registered. It would be pro bono work where I assist a security guard at my building who has a labor case, who has a dispute with the employer. So that's the kind of pro bono work that I've been attending to, CJ.
Yes. Well, I'm sure you speak for a whole lot of us. Not anymore now for me, but we've had to assist from church disputes,
Yes.
the sub-head man.
That's the kind of work, CJ.
You've been a member of the Advocates for Transformation since 2005.
That's correct, CJ.
And you chair it now.
Well, my period in office ended on the 19th of September this year. So I've been the chair of Advocates for Transformation in the KwaZulu-Natal region for 2 years.
All right. I'll stop here and hand you over to JP Boyorot for further interrogation.
Thank you. Thank you, CJ.
Thank you, CJ. Good afternoon, Advocate Chikela SC.
Good morning, JP.
Afternoon.
I beg your pardon. Good afternoon, JP.
I understand. I must say, I still feel elated even this day when I come across a senior counsel who is a woman, particularly an African. So you've done us proud as the women of this country.
Thank you, Jay.
And might I say in KZ, and I think you are the third African senior counsel from now Judge Norman. Then I'm not sure between you and Advocate Kuzoyo who started.
That's correct, CJ. Before
I received that prophecy of CJ, but it's JP for now.
JP, thank you so much. Before Judge Norman was elevated to the bench, it was her on top, and then it would be Advocate Kuzwayo and myself. But now my senior in terms of African female silks is Advocate Nomusa Kuzwayo.
Yes. And I was touched by your gesture last year when I started office, yourself as the chairperson of the Advocates for Transformation, and Advocate Mahabir SC, another woman who was chairing the GCP. You ensured that on the very first day you came to my office and said you were there for me, and in fact, you walked the talk from that day.
Yes, JP, we were driven. We had one mandate, and that was to lead the KZN bar. Advocate Mahabir was the chairman of the bar, elected by AFT. And at the time, I was the chair of AFT. So we both had an obligation of leading together the bar. So that was what was driving us at the time.
The only thing you did not do was to agree to my invite for you to act.
That's correct, JP, because at the time I thought I should focus all my energies in AFT and the leadership of the bar, supporting our chairperson, who was the first African, who was the first Black woman to lead our bar. So I felt that let me for once be selfish and focus on that responsibility alone.
Yes. And I see from your CV you chair the transformation committee of the GCB.
Of the KZN advocates of my bar, of the KwaZulu-Natal bar.
What does that entail? What do you focus on?
Basically, JP, we have a committee which is called the Skills Transfer and Transformation Committee of the bar. So what we do there, I have a committee of dedicated advocates. So we come up with ideas on how to transfer skills to the junior members of the bar. So what we do, we invite judges, especially from our division, to come and give lectures and give us talks on how to improve our skills as advocates appearing in court on a daily basis. So we've invited judges from the SCA and judges from your division, JP. We've also invited senior counsel and other junior members of the bar who to come and make presentations on certain topics. But in terms of transformation, we realized right at the beginning that most of us do not have an understanding of what transformation is or what is it to transform the bar. So we would organize talks and seminars and would have speakers to talk to us about what it means to transform the bar and to be gender sensitive. So basically that's what we're doing. We tried on a monthly basis to have a talk on a monthly basis, and I would be leading those. Not necessarily giving a talk, but I would be organizing those talks, and I would go there and be physically present to make sure that things go well.
And you were part of the team that assisted during the recess to deal with appeals in criminal matters?
Unfortunately, JP, I was not, because I had finished my term of acting and I had set aside 2 weeks, if I'm not mistaken, 2 weeks or a week to attend to my part head. So I was not available to assist in that regard.
And in terms of the, how did you find the acting both in Maritzburg and Durban, and do you have any preferences?
Well, JP, I must say, at the beginning, right at the beginning in 2018, when I was posted at Durban, it was daunting until my first day in motion court. By the time I was in matter number 4 of my role, I had settled comfortably. I was in control of my court. And since then, I had never looked back. I've managed all my court roles. I've managed the work that was allocated to me, and I've enjoyed each and every acting stint. And I've received overwhelming support from the judges in the KZN division and even court staff. So I've found it to be very interesting, JP.
And I'm aware that you attended the aspirant judges training sometime.
Yes, JP, I have. I think it must have been 3 years ago, but I attended the aspirant judges course here in Johannesburg.
How did you find it?
Well, because I had acted for some time, some of the concepts that were introduced there were not new to me. But I benefited a lot in terms of judgment writing and in terms of the posture of a judge, what it means to be a judge inside court and outside court. And I must say I learned new concepts And I think it was very useful, and perhaps I am able to do what I do better because I've had the benefit of attending that course.
Yes. I have not seen your name on the list of reserved judgment. Does that, how long have you been reserving judgments for?
I don't have a reserved judgment, but...
No, in the ordinary list, we get a list if you've reserved more than 3 months or 6 months in the division.
Yes.
So I just want to check, perhaps the question should be, what's the longest period have you reserved a judgment for?
Yes. JP, I would say the longest period would be 3 months and few days. But recently, all my judgments have been delivered within 1 month or 1 month and few weeks. And I've learned that skill from the work that I do at the Financial Sector Tribunal, because the norm there is that you issue a decision within 1 month of sitting. So I've improved from the 3 months period to at least on average, I would say, 2 months.
Thank you. Thank you, CJ. That will be all.
Thank you, JP. Premier?
No, thank you, Chief Justice. No, I have no question.
Thank you. Commissioner Matolo-Lepu?
Thank you, Chief Justice. Good afternoon, Advocate Riel.
Good afternoon, Commissioner.
You know, I was quite happy when you said the state attorney gave you work. At least the minister must be proud of one part of the state attorney, that is KZN. But what I wanted to find out, the type of work they actually gave.
Well, at the beginning, Commissioner, at the beginning of my career, we were kept busy with the matters like your matters from the Minister of Police. That would be the damages claims, medical negligence, and then it would be disciplinary hearings where a government employee is involved. Then as I gained experience, then I received more civil trials and motion court work. I must say my practice has been mainly motion court work, your civil court applications, both unopposed and opposed. Recently, Commissioner, I've been getting a lot of land claim matters and arbitrations from the state attorney. So they do assign to me work that is of equivalent status to the work of senior counsel. Except for what I've mentioned before, that doesn't entail commercial work.
Thank you. Thank you. At least a vast variety of work. Thank you.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Mangena?
And I just follow up this, unless Commissioner Mangena has a different question.
No, you can follow up.
You see, Mr. Girl, I always have a problem with this thing where somebody says, I don't have commercial work, and then you look at their CV, you find that they sit on the FSP. Because that is commercial work, you see. So I don't know, maybe it's an issue of like classification or what. You see, if it had been anyway, let me not be. Because I think if you had a different person sitting where you are and you ask them, do you have any commercial experience? Of course I do. You know, so.
Yeah, we know that kind of person.
Perhaps I should qualify that, Commissioner Ngulaitobi, and you're quite correct. The work that I do, or that I did as a member of the Financial Sector Tribunal, yes, I was appointed because I was a practicing advocate, but I'm sitting there to adjudicate. So the commercial work that I'm referring to would be your normal, usual advocate's briefs, where I would be the one who's representing a client in court.
No, I accept that. I'm saying that You know, so far when I've been listening to you, I get the impression, okay, I don't have commercial experience, but in reality, you do.
I do.
Yes, I mean.
I confirm.
Yeah.
Yes.
Good afternoon, Advocate.
No, we have another follow-up, Commissioner.
Yes, I'm following up on it. I'm just helping the candidate.
Is yours a follow-up question?
No, but I wanted to start with a follow-up. No, it's fine, CJ.
Then let me allow this follow-up question.
Thank you, Chief Justice. Good afternoon, Advocate Chikela.
Good afternoon, Commissioner.
I've been listening to your answers, Advocate Chikela, and I want to raise an issue with you more for the benefit of the minister than for yours. But I think it's a very stark description of the reality of black women at the bar. If one had to remove from your growth and development at the bar the state attorney work that you received over the years, what impact would that have had on you?
Wow. I would say a great impact, because throughout my years of practice, I would categorize my practice as have received about 70% of state attorney work. That has enabled me to take my children to school. That has enabled me to get a home for them, pay subscriptions, pay rental. That has enabled me to be considered by my colleagues worthy of silk status. So that's the impact of state attorney work in my practice. I don't know if I've answered your question.
You have, Advocate Chikela, and can I say that you're not the only black woman that has had that experience? Yes. I think that's par for the course for all of us. I want to ask a second question, and that's for you to address the consequence of procurement processes on the part of the state attorney, where they limit new briefs to counsel, including black women, one every 3 months or one every 4 months. If you can just address that.
It's sad. It's sad, and I know that there have been various attempts to challenge that through the courts of law. But the sad reality of it, and I'm going to speak for my bar, is that it seeks to close the doors completely to baby junior advocates because they do not have experience. One of the factors that you must satisfy, one of the requirements that you must satisfy in the bid documents is the experience in that particular field of law. So they are unable to bid successfully and get briefs. That's the challenge number one. Then the second challenge is that it sort of limits practitioners to specific categories of law. Because if you say in the bidding form that you have an amount of experience in administrative law, you are sure to receive more matters on administrative law and no matters on tax law because of what you've stated in your bid document. But other than that, there are other requirements that you have to provide a certificate of good standing. Some advocates, they are practicing without a certificate of good standing, not because they've been mischievous, but because they have not been able to pay their bar subscriptions. So you are caught between paying bar subscriptions and paying rental, putting fuel in your car, buying food, and taking your children to school. So it's really not a good position for advocates to find themselves in. But I understand that there are processes dealing with that. So I'm not going to go further, just in case I risk saying a lot.
And final question, Advocate Chikela, is notwithstanding all those crippling systemic obstacles to black women at the bar, you've not only survived, but you've thrived. And the question I have for you is, why in those circumstances do you want to go to the bench and not continue to make your mark at the bar?
Yes. I've been asked this question many a times. I must say, Commissioner, I truly enjoy my life at the bar. I enjoy the work that I do at the bar, the contribution that I make. However, I believe that I can still contribute within the judiciary. I take this as the normal career development or career growth of a practicing advocate. But more than that, I believe with my experience as an advocate, with my skills in litigation, I would be able to contribute meaningfully to the KZN division. Insofar as the charitable work that I do or the transformation programs that I engage in, I can still continue to do that even if I am elevated to the bench. And one way of doing that as a judge is exactly as I had explained, by participating in the skills transfer programs of the bar.
Thank you. Thank you, Chief Justice.
Luckily, we have
Follow-up.
a black woman minister who cares about these issues. So we hope she's listening very carefully. And what is heartbreaking, I did not want to say anything about this. What is heartbreaking is that the next generation of black women advocates is suffering the same challenges I went through 25 years ago in our democracy. So that's what we're dealing with, Minister.
May I follow up, CJ, on
Oh, yes, JP.
Yes, thank you. You're not being candid about also why you're coming. You survived more than 3 JPs trying to convince you to come to the bench.
Yes.
Yes.
Yes, I've survived more than 3 JPs. And my reason has always been I want to practice as senior counsel. Can I be given an opportunity to live that dream? And then the other reason that I would give was that my children are younger. Until I ran out of reasons, the current JP was counting because I had said I would avail myself when my youngest child is 10 years old. He has turned 10 years old just last week. So I could not, change that. So I am here now.
Thank you, CJ.
Because of that.
CJ, may I ask a follow-up related to this matter? Thank you very much. Advocate, yes, I'm over here.
Oh, yes.
Advocate, just maybe to build on what Commissioner Pillay and maybe the JP and also the CJ spoken to. Apart from having the minister in the room, you also have, I think, 6 or 7 members of parliament in the room as well. And it's not exactly a legal question, but it is one in which there's one role for the minister to, in fact, there's many roles for the minister to play in opening up access. But I'm interested in your thoughts on this side of the table. Do we need to be legislating more to open up the space? Is it a matter of, do you think that's going to help the culture in terms of changing the space? What, from a policymaker's perspective, in your opinion, do you think needs to happen to open up the way for Black women in particular to not only make it, as Advocate or Commissioner Pillay has said, not only survive in the legal fraternity, and I'll say it is a fraternity, it's a club, you're either in or you're out, and what do you think needs to happen for Black women in this country to thrive in this space? Thank you.
Thank you, Commissioner. Perhaps progressive government policies would help. I do not believe that there is a need for legislation to be enacted, because we find ourselves now as advocates in a position where we have to tender and bid and be asked to conform with the provisions of the Public Finance Management Act, something which really does not fit in with the profession of advocates. And I always fear that if the profession is overly legislated, perhaps that would compromise the independence of an advocate. And it's something that we have so far managed to jealously guard against losing the independence of advocates. So I think progressive policy, which should enable Black female advocates, or even just female advocates in general, to access more work and to be paid timeously. And I want to emphasize on the issue of timeous payments of counsel's fees, because most of us, we do get work, but we are not paid on time. So that's what I think would make our lives better. Thank you, Commissioner.
For follow-up, CJ.
Oh, sorry. The voices are disembodied in here. Commissioner Moimang?
Thank you, CJ. Good afternoon, Advocate Gela.
Good afternoon, Commissioner.
Just in terms of the recent publishing of the legal sector code by Minister Paxdown, which was done on the 11th of September this year, which clearly I suspect will have to give this intervention an opportunity by virtue of the fact that for us to be where we are, it needed a litigation. The former Minister Patel was taken to court to ensure that there is a legal sector code in terms of the BEE. Are you of the view that this code will be able to address some of the issues that challenges that you have alluded to? Thank you.
Thank you, Commissioner. I have not had the benefit of going through the code, but I had seen it in its draft form when it was circulated amongst practitioners to comment. Though I cannot specifically take you to the specific provisions of the code, but I am aware that there are a few provisions which seeks to address the issue. I'm not so sure if they will sufficiently address the issue, but I believe it's a start towards the correct direction. Thank you, Commissioner.
Thank you, Advocate. Thank you, CJ.
That's me. It was me, Chief Justice. They took all the questions.
I'm sorry, I forgot all about you.
Yeah. Good afternoon, Advocate Jigel.
Good afternoon, Commissioner.
Yeah, all questions have been taken, and I'm glad that you raised the issue of non-timeous processing of payments to advocates, because it is one thing to be allocated work and another to be paid in time. And it doesn't help to get work but not to be paid, because then you are being turned into a slave. So you need to emphasize on that point, and I did not hear you emphasizing adequately on it. But here's my question, and it relates to your children. One is 16, the other is 10. And seated here and looking at you, I asked myself if you have taken time to find out what kind of support is there in the office of the OCJ, particularly to judges, insofar as matters of mental wellness is concerned. Because given the load of the work, you may find yourself in a situation wherein the situation at home is affecting your work, but there is no support that is coming. So have you applied your mind to that aspect as well?
Thank you, Commissioner. To be quite honest, I have not made inquiries as to what programs are there. But I have had several discussions with the current JP regarding my primary role, and that is of being a parent to my children. And I fully understand that she takes that into account in each and every one of her judges, especially those of us who have young children. But more than that, as you would have seen from my CV, I decided right at the beginning of my career that I should start a family. I wanted my children to grow with my practice. And we have developed a system at home where I have support from my immediate family members and from my partner, and who is the father of the children. But more than that, I am not afraid of working long hours or heavy workload. That's what I've been doing all my life as a practicing advocate. And when I started being invited to act. So we have a system in place, but I will make inquiries as to what support is there. But so far, I have not felt the need to seek help in that regard.
Thank you. That's all, CJ.
CJ, may I just allay Commissioner Mangena's fears that when you were appointed, I think your baby was a few months when you were appointed, CJ, as a judge. But when I was appointed...
I fell pregnant on the bench. I was the first judge who ever fell pregnant on the bench in this country.
Yes. And
CJ, the issue is, did you get the support from the system and the administration?
Yeah, so I'm coming to that to allay your fears. My daughter was 8 years old when I was appointed as a judge, and my son was 6 years old. I've had very understanding judges president, and I dare say I would never do otherwise, particularly for another mother. Thank you.
She would be lucky because she would be joining a judiciary led by a woman, a mother who's experienced exactly what she has, and a judge president who has lived that experience. So
Sorry, CJ, can I just follow up? Does Commissioner Mangena want to withdraw the question?
No, not at all. It's a system issue. It's a system issue.
It's a very legitimate issue, Commissioner Mangena. I agree. Commissioners, may I just remind you that we still have 3 candidates to interview. So unless a question is absolutely necessary, I ask that we limit ourselves.
Thank you.
We've kept those people waiting for hours now. Commissioner Trolley?
Thank you, Chief Justice. I thought you'd forgotten me like Commissioner Mangena. Advocate Jikela, thanks very much for the opportunity to ask you this question. Having appreciation for what you've told us about being a black woman advocate, and considering the sentiments and comments made by Commissioner Pillay, reinforced by the JP and the CJ in this regard, I see that you had a stint in government employment in KZN, COCTA. Can you tell us about that experience? I see it was short-lived. So you left your practice and went and worked in the government for 6 months and went back Maybe you could just tell us how that came about and what resulted in the short service.
Thank you, Commissioner Chalup. At the time, I had been doing a lot of local government matters, and I was headhunted by the Department of, by COCTA, KZN, to support them in the unit, which was municipal governance. And at the time, my son was 3 months old, and my office was in Pietermaritzburg. And little did I know that that role required traveling to various municipalities within KwaZulu-Natal. The furthest that I've driven was to the border of Mpumalanga and KwaZulu-Natal. It was a day's trip. I had to drive back home and to be with my son, who was a baby at that time. And in as much as I thought, I could add value to COCTA and in turn gain some experience, because I did not have any intentions of leaving the practice of the bar permanently. It was going to be for a brief period. But unfortunately, I had to choose my family. And for that reason, I resigned within 6 months of being appointed, because there was a lot of traveling. And you would appreciate that, Commissioner, as a practicing advocate, sometimes you don't travel that much, especially when you are a senior junior, not silk. So that was the reason my stint with COCTA was brief.
Commissioner Likhanyan.
Chief Justice, I listened very attentively when you made the remark, I'm persuaded. Thanks very much, Advocate Jikela, for your fortitude and resilience. Thank you so much.
Thank you, Commissioner.
Any questions from the virtual platform? No. Commissioner Breitenbach? Thank you, Commissioners. Well, that's it then, Ms. Jikela. We've reached the end of your interview. I just want to express my pride that someone who came through these hands, even if it's just one course, has come as far as you have. Well done. No matter the results of this interview, I'm proud of you.
Thank you so much, Judge, and thank you for the opportunity.
You're excused.
Thank you.
I decided not to raise anything because
to discuss in camera.
Before we call the next candidate.
Yes, but it's going to be 1 minute.
All right. May we kindly ask the media to please give us a bit of privacy. Good afternoon, Mr. Khalil.
Good afternoon, Chief Justice, and good afternoon to all the commissioners and our JP and KZN as well.
How do you feel today? Are we well?
Oh, it was hectic. I hardly slept. I had to reflect on a lot of things, and correctly so, I think. And but it's been really, really hectic. But thank you. I am fine.
All right, good. Yes. Well, I promise we won't keep you long this afternoon.
Yes.
And we just spoke to you 24 hours ago, literally.
Yes.
So we know exactly, we remember vividly exactly who you are.
Yes.
So I'm not going to put anything to you.
Yes.
And I will give JP, the KZN JP and her premier, and any other commissioner who may have a leftover question from yesterday to question you. But it
Yes.
should not take long.
Yes, certainly.
All
Thank
right.
you, Chief Justice.
On that note, JP.
Thank you, CJ. Good afternoon, Mr. Khalil.
Good afternoon, Judge President.
Yes, I watched the interviews yesterday that you were interviewed for yesterday, and you were not recommended for the Eastern Cape for various reasons other than the reason that you have not acted in that division. So I make the point that it was not for that reason only that you are not recommended according to how you fared from what I saw on the interview. There were various lot of concessions that you made about your readiness and ability. Why would you think that would change for KZN?
Sorry, you're saying I made lots of admissions regarding my ability?
Of readiness to becoming a judge?
No, I don't think I made any admissions. The admission that I made was, Judge President, I was asked a question, if I remember correctly, whether as a magistrate, just purely as a magistrate, whether that would prepare you for the High Court. And I indicated, in my view, not. One must have acted in the High Court to understand and appreciate the intensity of the work.
Perhaps to rephrase my question then, it will be, yesterday this body decided not to recommend you for appointment in the Eastern Cape. Myself and the Premier are the only two people that were not there yesterday.
Yes.
Why would you think that would change today?
I would think that if I'm asked questions about the work that I've done, what I've disclosed in my CV, and asked more questions, perhaps that may bring to the fore other factors. But yes, sorry, JP. Yes, just about yesterday, upon reflection of what was discussed yesterday and what I became aware of, which was not known to me at the time when I accepted the nominations for other posts. I would certainly not have accepted that. And what coming from a senior judge like Judge President Lampo, although he did not provide any prescripts, just listening to his advice, I think it would be unbecoming of me not to have considered that last night and to have reflected upon that. And I think it's a reflection on my character if I did not do that. And I wanted to say to the Commissioner, I meant to say it at the end of this interview, but perhaps I could say it now, that I withdraw the acceptance of the nomination for the posts where I have not acted as a judge of the High Court. I understand and appreciate, and I understand that it was not put forward as a criteria by JP Mlambo, but I understand and imagine as a junior judicial officer, if I did not reflect on that, it would reflect very badly on me. So I just wanted to say that I do indeed do so, not because of any pressure, but because of what was discussed, and I understood what was discussed yesterday, particularly relating to being in the High Court in a division where I have not acted.
Sorry, JP, may I just get clarity? Are you saying you are withdrawing your candidature for the position advertised for the Limpopo division?
And Western Cape.
The Western Cape as well. All right. We have noted that. Thank you.
Yes, and I just want to repeat, I do that freely and voluntarily based on what what I learned yesterday, which was not within my knowledge at the time when I accepted the nominations. Thank you.
Thank you, Mr. Karen. Carry on, JP.
Thank you. And lastly, on my side, CJ, Judge President Mlambo brought it to attention that for a person to act or even to be nominated, they get identified by their peers. Your nomination letter is from your ex-boss, if I may say that, the previous.
Yes.
Yes, it sounds like a motivational letter for promotion. So how do you compare the two? You know, your peers identifying you for nomination, various advocates or various other magistrates other than your direct boss that would write the motivation for you.
Yes, I take that point, but what I can comment on, JP, is nobody would know you better than your immediate supervisor or boss, as you put it. And it wasn't for the first time that he had nominated me. He's left the profession quite some time. And I do understand, and I've received from the commission comments on my nomination. And I omitted to mention that I thank all the law bodies for having taken the time to have gone through all my judgments, my CV and my history for those two posts, and to have made comments on that. For me, initially, JP, I was really happy. You know, when I was shortlisted, when I learned I was shortlisted for so many posts, and in my mind, that served as some confirmation for me that I would not have been shortlisted had the Judicial Service Commission not seen value in me. So I truly appreciate that, and coming from the background that I do come from and all the various comments, it adds a lot of confidence, and I think it can be an example for other magistrates as well, that the way you try to work as hard as possible, minus what I didn't know at the time when I accepted the nomination in other provinces, that you can be given recognition for that.
Thank you, CJ. That's all.
Thank you, JP. Do you have any questions for the candidate Premier?
CJ, no, thank you very much. I don't have a question.
Thank you, Premier. Commissioner Hassan?
Thank you very much, CJ. Over here, Mr. Khalil, Commissioner Hassan.
Yes, yes.
Some questions I had, and I didn't want to pose them yesterday because we were dealing with the Eastern Cape Division, and today, of course, we're dealing with KwaZulu-Natal, and therefore I want to ask a few questions related to the work that you've done within KZN. Yes. If I'm not mistaken, Mr. Khalil, you've dealt with some of the July 2021 unrest and some of the key cases in Phoenix, if I'm correct.
Yes, I have.
Right, so protest, as we know in South Africa, is almost part and parcel of our history, but it's also part and parcel in many ways of our identity as South Africans. It's a right enshrined in the Constitution, etc., etc. But so often it's also the last point of call for our communities, especially young people who tend to be at the forefront of service delivery protests, etc., etc. And we've also witnessed, Mr. Khalil, police who tend to be very heavy-handed and often arrest community members en masse at a protest. So I'm interested in the context of July 2021 and the Phoenix cases as well. For the purposes of conviction, which legal principle would you use to distinguish between a guilty person and those who happen to be exercising their right to protest, and those who are actually guilty of the crime? We know the doctrine of common purpose is quite a controversial one, especially in our history, legally speaking, but I'm very interested to know what legal considerations go in, because you've dealt with some of these cases, between those who are guilty and those who are just at the protest. Thank you.
Thank you. I don't think it happened, Commissioner, in the context of a protest. There was large-scale looting, as we all saw it on television. There was a large scale of violence, and I dealt with the matter in the context that certain alleged perpetrators were arrested, and it was at the time where the police were largely absent or even overwhelmed. And a lot of I think if I remember correctly, there were 38 murders in Phoenix. And the army was at our courts, just to give you the context of those matters. The reason why I dealt with those matters is some of the other magistrates that I allocated the matter, or I intended to allocate the matter, were afraid. They had family living in Phoenix and friends. So as the acting chief magistrate, and I've done it on many other occasions, I had to lead from the front, and I think I spent almost 2 months just dealing with those matters, and in a lot of those matters it was mainly senior counsel. So that is the context in which I presided over those matters, or quite a number of those matters. And it was really hectic. And the one matter you asked me about, it is a matter where I had refused bail, because the finding I made on a prima facie level, and after having watched, it's not often in a bail application where you have the opportunity to actually watch exactly what had transpired. And there was a very senior counsel in the country that I think came out of retirement. He did the matter. But in any event, he withdrew. But when I saw that video, it causes you to go home, you cry, you ask, but what motivated other human beings to act in the barbaric manner that they acted? And the finding that I made was on the basis of common purpose on a prima facie level. I accepted that the state had a strong case. I refused bail on various grounds. It's like a 52-page judgment. And the one finding I did make was that the attacks, in my view, in terms of the evidence, were racially or based on racial profiling. That is the number of cases that I made. The other difficulty was that in so many of these matters, lots of the suspects were allegedly assaulted in prison. They were not given sufficient food. They were robbed. And it was so many dynamics in those matters that I eventually had to take the course of having the head of the Correctional Services subpoenaed to court to deal with that, to deal with those issues. But the short answer is that in exceptional circumstances in the bail legislation, and I found these to be exceptional circumstances where it would cause public outrage, where it invokes a lot of, basically outrage and public disorder. And because of the strong prima facie evidence, in my view, and I use the one leg of the bail legislation, which says only in exceptional circumstances may you do so. It's been referred to as the Lynch law or so, but I thought it best, after having considered all the evidence, that there were no exceptional circumstances which justified the release of the applicants on bail. So it was really hectic, but it's fine. I mean, we all deal with these types of matters. But during that period, we've had magistrates being disallowed to come to court on public roads, the senior magistrates, couple of them. And they asked me for, at that time, if you remember, during COVID-19, you have the COVID permits that were issued. I discussed it with them and I said, I find it unacceptable to give any magistrate a permit to come, because you need a permit to travel on a public road in South Africa? And these were two senior African magistrates. They understood, it toughened them up, etc. as well. And there were no problems. But it was hectic psychologically, emotionally. I've never, ever presided over matters like those matters.
Sorry, Chief Justice. If I could, I know the agreement, but sometimes you sort of try to help. I think the question is, what is the legal principle to distinguish the guilty from the not guilty? Because so far you've identified common purpose. Common purpose expands the net of the people that are responsible beyond those that can be immediately identified.
Yes.
And it's controversial from as far as Safatsa. The question is, how do you distinguish the guilty from the not guilty? We have a mass uprising, a mass looting. You don't know who was looting, who was not looting. The police have just arrested 1,000 people.
Yes. Thank you, Commissioner. Can I just say that perhaps I should have indicated this, that in quite a number of the matters, it was based on a Schedule 6, what we commonly refer to as the Schedule 6 bail application, where the onus is on the applicants. The applicants procedurally started first by handing in affidavits and saying exactly what you have suggested, that there was looting, etc. But from the videos that we watched in court, there was no such looting. For example, you just find 4 youngsters walking on the road, and suddenly a whole group of people come in a bakkie, all armed, and start attacking the 4 youngsters. They run, they come out of where, or they weeded out, and then a continuous stabbing by one person, then another person, then a gunshot to the face. It was in that context, I'm saying, it wasn't as if there was a protest and there were certain people and others were just hanging around. It was an attack on persons who were just walking unarmed, no evidence of any looting, nothing at all. So I used a common purpose on a prima facie level to say that even though one person may not have stabbed the deceased, for example, in one of the cases, but the others by helping to weed them out, the others by perhaps maybe shooting them or shooting one person, the others by assaulting them or blocking their way. So it is on that basis that I made the prima facie finding. So it wasn't in the context that people were looting and others were just standing by and where the police arrested them.
CJ, just my second question. I'm not going to berate the point on the legal principles, but Mr. Khalil, you've also presided over a number of equality cases, particularly those that have been constitutional in nature, dealing with racism in social media, which has been quite interesting given, of course, we're seeing a lot more proliferation of hateful content online. And I think some of your findings have gone quite a long way in demonstrating that there's no place in a democratic South Africa for racism, of course, but particularly also for racism as they are in social media posts. I mean, the Penny Sparrow case, if I'm correct, you presided over or participated in some shape or form. And that's, of course, changed society. And just before I ask my question, it's related. It's also an example of how powerful progressive judgments can be and the kinds of messages it can send to society, that there are consequences for this kind of behavior. So, Mr. Khalil, I'm interested in how long you've been a chief magistrate and how long you acted as a judge and how you think that this has prepared you for a potential seat on the bench. Thank you.
Thank you. For the past 21 years, I think I've been a magistrate. And out of those 21 years, 15 of those years have been in management at the lower court level, at the magistrates court level. I've acted as chief magistrate at Pietermaritzburg for a few months. I've acted at Durban, and currently I'm acting for almost 7 years at Verulam. That post has not been advertised because of the relocation of that post to the far northern areas of KwaZulu-Natal, areas like Umzinyathi, Umzimkhulu, Zululand. They don't have a chief magistrate there that is close to those courts. So it has been decided that that post will be relocated and then the process. So it's for almost 7 years I've been an acting chief magistrate. The Equality Court cases, yes, the most recent one I've done is on albinism in South Africa, and that's a huge problem. You know, we see these matters on the media, and it was quite a taxing case. And with respect and the greatest humility, I didn't submit that judgment because I delivered it after the acceptance of the nomination and the completion of the questionnaire. But you're correct in that in all the equality court matters, you're dealing with constitutional rights. You're weighing up one right against the other rights. You're contextualizing the disputes in order to arrive at a fair and just conclusion. These matters as well, it puts you under a lot of pressure because of the findings you make and your judgment. Like in the Phoenix unrest-related cases, I was advised by security not to go into the Phoenix area for almost a year and a half after I finalized these matters. So I think it has prepared me quite a bit, especially the Equality Court, because the Equality Court has very similar powers to the High Court. In the sense that you may grant prohibitory interdicts, you may grant declaratory orders, you have the option of getting progress reports on the various orders that you do indeed make. So, for example, if you tell somebody or you order them or direct them to apologize, you direct them to put up a video, for example, to apologize in the same way in which the initial video caused the complaint. You can ask them to do so by a certain date for them to file in all these progress reports, because it's well and good giving the orders, but for the orders to have meaningful effect, I think you have to have these progress reports. So I think all these matters, just very briefly, has given me a lot of experience, and it has opened up my insight. And if one looks at the comments made by the various bodies on my judgments, I did say initially I thank them because it gives you so much of confidence that others would have looked at your judgments and they would have made various comments on your judgment and going through that.
Thank you, CJ.
Thank you, Mr. Khalil. Thank you for returning today. You're excused.
Yes, thank you very much, Chief Justice, and thank you to all the commissioners. I appreciate the opportunity. Chief Justice, I will write formally to the Secretary of the JSC.
You need not do that.
Oh, I need not.
She's right here. You are on record.
Okay.
This is what you did is far better than a letter that may get lost in the mail.
Certainly. Thank you very much once again.
Thank you.
I thank you.
Good afternoon, Mr. Pickman.
Good afternoon, CJ.
Did I pronounce your name
Yes,
correctly?
you did.
Okay. How are you?
I'm okay, thank you.
You look quite nervous, don't be.
It's been a long
relax.
day.
You state that you have 2 degrees, a BA and LLB, acquired from the University of KwaZulu-Natal.
Yes.
I just got curious in regard to your LLB degree.
Yes.
You mentioned that you were assisted financially by the Department of Justice.
Yes.
But at the same time, you say your father had been a successful and well-respected advocate. Why would you have needed to be financially assisted by government?
I think that one of the reasons was that I grew up in a family which encouraged you to make your own way. So that was, so for my BA, I got a bank loan. And for my LLB, I got a bursary. And I worked, interestingly enough, in a butchery on weekends as a student job.
But then your dad died tragically.
He died while I was writing my last LLB exam.
Sorry, that's terrible.
At that stage, I was a member of the SRC, and I came out of that last exam to the SRC secretary and a couple of the members there to tell me the sad news. But my parents had been divorced for many years, so I hadn't lived my whole life with him. But after starting to study law, which was his profession, career, our bond became a lot stronger. And then he'd also been involved in politics. and we'd had a connection there. So at least when he died, we had restored some sort of good family relationship.
Yes. Sorry for your loss.
Thank you.
So after your studies, you were the department. Well, you owed it. They snapped you up, put you in a position of public prosecutor. But you spent the first 2 years in military service.
So what happened? What happened was that because of the bursary, I had to report to the Durban Magistrates Courts on the 1st of December, I think, of the year that I finished my LLB. And I then was employed formally as a prosecutor from that moment. But at the end of December, I was put in a cattle truck and sent off to Pretoria.
And you were there for 2 years?
And I was in Pretoria for what they called a junior leadership course, which was a section of the army that utilized varsity graduates. I became a law officer and then ended up spending the last 14 months in a town called De Aar, which is in the Northern Cape, as the law officer.
What did the law officer do?
It was an ammunition depot. I think it still is. It had a contingent of guards from all over the country who would come every month. A whole lot of guards would come and sit in those towers surrounding the ammunition depot itself, which, interestingly enough, is situated in an extinct meteor crater, which gives it natural protection all around the ammunition depot. And then there are these guard towers. And what we would have to deal with was guards shooting each other, guards driving vehicles into having accidents in vehicles. There was a constant stream of issues that the law officers had to deal with, the law officer, myself. That involved, if it involved a court martial, it involved catching the train to Pretoria, which was called the milk train, because it picked up milk at every farm that it passed. So the train trip was literally hours, all night and all the next day.
So when you finished your national service, you went back to the department and actually started practicing as a prosecutor?
Yes, I was contractually bound to do that. I was paid as a public prosecutor while I was doing national service. So my contract with the department was then a 4-year contract, the 2 years of the bursary and the 2 years of being an employee whilst doing national service.
So when you completed that contract, you went into the magistracy in 1990?
Yes.
That was not part of the contract now?
No. I did the 4 years that I was contractually required to do. It was just over 4 years, actually. District court and then regional court prosecuting. And I enjoyed the environment. I enjoyed litigation as a trial lawyer. I always have. And I thought it would be in my interests to gain experience presiding, bearing in mind this was all criminal work that I was involved in, presiding in the criminal courts. And in those days, the chief magistrate could just appoint you. And I then volunteered to stay on for another 4 years, presiding as a magistrate in the district courts.
Until you decided in 1994 to go and do your pupillage and join the bar?
I had always wanted to, Chief Justice, be an advocate. I wanted to honour the memory of my father. That's why I had done it. I knew I was going to go eventually. And that was the point that was the most sensible for me to make the move.
And you've been a member of the KwaZulu-Natal Society of Advocates for the past 30 years?
Yes.
Doing what kind of work?
Chief Justice, I have varied practice. As I say, I consider myself primarily to be a litigating advocate. And I have had a practice which covers everything from representing people in crime for the first, obviously, 4 or 5 years of my time at the bar. Because of my history in the criminal section, I got a lot of criminal work. So I did a lot of criminal cases, and then I made a point of slowly moving away from that into the commercial and allied field of advocacy. And I've done everything from small helping people with state agency claims to very high profile commercial matters. It's a real variety. I have not specialized in anything.
Do you have are there any judgments, reported judgments, that is, in matters in which you appeared as counsel that you know of?
Yes, there are.
About how many in estimate? Or if you have the exact number?
At least, I think some of them I've mentioned in the judgments which talk about where I acted in cases that I thought were significant in my questionnaire.
No, I mean as an advocate.
Yes, no, I'm talking about.
So
So I answered questions there about cases that were significant while I was an advocate, and most of those were reported. But there must be 30 or more.
All right. And when did you start acting as a judge?
I was first asked to act as a judge in 2020 by Kruger J, who was the acting DJP at the time, I think, for a 5-week stint. He asked me again a year or so later for a 5-week stint. And then I think about last November 2023, through till about 3 weeks ago, I've done a lot of more acting stints.
Okay, so it's 10 weeks plus 3 sessions.
It was 30 weeks, I think, when I did my application. It's now 35 weeks, 35 or 36. 35 or 36. Now, I stopped a stint 2 weeks ago.
Oh, I see. And what kind of cases were you allocated?
So the JP kindly gave me some time in the criminal section just so that I could see the difference between what it was like to preside in the magistrates' courts and what it was like to preside in the criminal high court. I did a couple of sessions there, maybe 3 by now, one in Maritzburg, a couple in Durban, I think, at least one in Durban. And for the rest of the time, it's been the civil section. And what happens in the KZN division, both courts, is that when you serve for a session, you get at least 1 motion court per week. You get, in all likelihood, a full court appeal, 1. But if not a full court appeal, you definitely will get at least 1 or 2 or 3 or 4 full bench appeals. For the rest of the time, you are on call to do trials. So for all of the sessions that I've acted, CJ, it's been everything. Motion court. I've just done the first week of recess in Pietermaritzburg, where I did 3 motion court days out of the 5, which covers everything. Trial work, whatever is handed to me, I do have done from commercial to RAF, and as I say, either full court or full bench appeals.
Right. What would you say? Well, how many judgments have you produced as an acting judge?
I don't have the exact figure, but I'd say about 26 or 27.
All right. Any of them reported?
No, they're not. They're not reported in the South African law reports or the LexisNexis reports, but they're all on SAFLI.
SAFLI, yes. No, I mean.
So they're published but not reported.
Yeah, that is the difference.
Yes.
Yeah. Okay.
Maybe I should add, CJ, at this stage that I set out in my application that there was one of my judgments had gone on appeal. And when I did the application, the result was not yet known. That judgment, the appeal judgment, it was a full court in Pietermaritzburg. I had refused leave to appeal to the Durban municipality, on a 30 million rand judgment. I had refused leave to appeal. The SCA granted leave to appeal. That was heard by 3 judges in KZN, and that judgment was handed down on Monday, and the appeal was dismissed. So, to be honest, I'm proud of that judgment.
Yeah, we know the feeling.
Yeah.
It's a good one. All right. All right. I will hand over to the JP to put
Thank
any
you.
questions she may have for you.
Thank you, CJ. Good afternoon, Advocate Pittman.
Hello, JP.
How were your acting stints, both in Maritzburg and Durban? And do you have any preference of the 2 courts?
JP, I really enjoyed my acting stints. I enjoyed both of the courts. I said at the beginning, I may have even mentioned it to you, that I will go wherever you want me to go if I get the job. I live in Westville. I can drive to Maritzburg, or I can act in Durban. Whatever is needed of me, I will do. I did enjoy Pietermaritzburg. It's the provincial division. It's a beautiful old historic building, and I enjoyed the collegiality of the place.
Yes, and I noticed that in your application you have been nominated by 2 senior council women members of the bar, and I think she's senior junior advocate Noko, and it's quite a diverse group.
Yes.
Is that some reflection on you?
I hope it's a good reflection. Annandale SC is someone I've known since my prosecuting days. I think she is an exceptionally bright advocate and someone whose opinion I have always held in very high regard. Gabriel SC has been a friend of mine since she started as an advocate, as she sets out in her letter, and I've always valued her friendship. She's also an exceptionally talented intellectual advocate, in my view. Nono Nako is an advocate who I have known. She was the registrar of the High Court in Durban, struggled her way through that, getting a law degree, and became a friend of mine when I helped ensure that she got a position in our group of advocates.
And I understand you introduced a nursery in your group of advocates. How did that come about?
Okay, so what happened there is my group of advocates has chambers in the Mshlonga Rocks. It has an upstairs and a downstairs, and there are about 20 of us. It used to be in town in Salmon Grove Chambers, but the point I'm making is that we've been together, most of the senior advocates, for a long, long time. Since COVID, I just became very aware of the fact that it was becoming more and more difficult for junior, previously disadvantaged advocates especially, to be able to afford the kinds of rentals that these institutions were starting to charge for the buildings where chambers were situated. And what I thought was, because a lot of people gave up practice as a result of COVID, and chambers became available, what I thought was, an idea I had was to divide one of the chambers up into at least 4 to enable juniors, and my focus was on previously disadvantaged juniors, to make it more affordable for them. And that's what we're doing, and that's what's working. And we've only had previously disadvantaged juniors.
Yes. The next one relates to your age. You will be turning 64 in a few weeks' time.
Yes.
And I must commend you that I have not felt your age in relation to your industriousness. You have worked hard, probably exceeded some of the younger colleagues.
Thank you.
The question that then relates to that, there are 2 actually. One is, will you have difficulties in respecting, in the judiciary and in the legal profession, the hierarchy is a big thing. The seniority, So now we will have a situation where you are 64 years old and you might have a judge who is 49 years old, who is your senior because she's been appointed before you. Will you have any problem in respecting that seniority?
Thank you for that question. And I'm going to answer it directly, but I'm also going to say that in answering it, I may touch slightly on what I will say when someone eventually asks me why I haven't taken silk, which I'm sure is coming.
I stopped myself from asking that question.
Yes. And that is that I grew up in a family where status was irrelevant as an attribute of a good human being. I have the personal philosophy that I'm better than no one and no one is better than me. My philosophy is that we are equal, whether you are a child or a 20-year-old advocate or anybody else, or a nurse in a hospital or anywhere else. I will have and that's how I've lived my life. I will have absolutely no problem deferring to someone who is younger than me. Maybe I should just mention something else at this point, which is interesting. I know that I said to myself I wasn't going to give long answers, I was going to give short answers in this interview, but I'm going to do it anyway. So I'm a self-deprecating person, I know that. I don't blow my own trumpet, I don't like it, I've never been good at it. If I have to do it today, I'll do it, but it doesn't come naturally to me. I went, at your request, to do the aspirant judges course in June. And people who had done it before me, who I spoke to, said to me, "No, you've been practicing for so long, you're not going to learn nothing. Go, but you won't learn anything." I said this to you, I found the absolute opposite. I loved every minute of it. I thought it was brilliantly put on. It was professional. Justice Matopo, who ran it, was outstanding. The quality of the judges who came to talk to us and gave up their own free time, their own time for free when they could have been and should have been writing judgments, was exceptional. And I learned things that I didn't know, had not known before. And it struck me at that moment that no matter how good I think I may be, there's always an opportunity to learn. And I learned there. And if you ever ask me to go on an aspirant judges course again, or another kind of judges course, I will leap at the opportunity. I think I've strayed far from the question.
Yes. So the short answer I wanted was whether you would respect those younger colleagues. Yes. Now, the other question relating to age is we have circuit courts, Madadeni, Pongola, Ofra had, that far. And recently I've had one or two colleagues who are about 67, 66 say to me, and they're quite junior, I must mention, say to me, JP, you must consider not sending us to circuit because of age. And I said to them, you are junior, you will go, you have to do your time. Now you are 64, will you have a problem? And this goes in hand with another question where we have younger judges that have smaller children who might not be able to go on circuit because of those needs. Would you have a difficulty in doing circuits even more often than not in certain instances?
No difficulty whatsoever. I am at a stage of my life on a personal level where my children are finally grown up, out the house. Obviously I've discussed this with my wife, this kind of possibility. It's something I did as a public prosecutor, circuits. I have absolutely no problem whatsoever. In fact, I would suggest that someone like myself is more suited to go and do something like that than someone with young children who needs mom to be at home.
Yes. I'm not going to go so much on judgments and your knowledge of the law because I think it's quite clear from the CV that you are quite knowledgeable and because of the number of years on the bench. But there are just two other aspects I want to canvass. And one is relating to the objection about your temperament. What do you believe in your view are good attributes for a judge?
Well, first of all, I have responded to the temperament allegations in full in writing, and I hope at least that the Commission has had a look at those. I'm obviously happy to deal with any further if necessary. Good. I think that, right, integrity is, I think, the most important attribute, and I have it. I do not lie. I cannot tell lies. I hate liars. The second thing is empathy. I think a judge has to have empathy. As a judge, you're not just sitting dispensing judgments in relation to disputes. You're also managing courts, and you're managing witnesses, and you're managing lawyers. And those people often come from very, very different cultural or other kinds of backgrounds. Empathy means the ability to stand in someone else's shoes. So I think it's a very important attribute, and I believe I have it. There are a lot of things that are needed of a judge: patience, calmness. But the last thing that I think the three things that I'm mentioning, the two I've mentioned already, and the third one is a work ethic. I can honestly say, as I sit here now, that I have never worked as hard as I have while I've been acting as a judge. Never in my practice as an advocate have I had to work as hard as I have to keep up to date with the stuff that you and the division has given me to do. So, and I could do it because I have a work ethic which doesn't allow me not to do it. And now I'm going to blow my trumpet. I have for 30 years woken up at 5 o'clock every morning. I get to my chambers, or if I'm an acting judge, to my office by 6, if it's in Maritzburg, 6:30, and I then work. And if you have a look at the judgments I've attached to this bundle of documents, you'll see that my turnover rate is about 2 or 3 weeks for a judgment, no matter how complicated, and some of these judgments were complicated. And that's because of a work ethic. So I think those are the attributes of a judge. I think the essential attributes of a judge.
Yes. And then finally, Advocate Pittman, there is that complaint about you not in that eviction matter.
Yes, it wasn't. It was actually a demolition matter.
Demolition, yes. And in fact, I was quite shocked because I had not received any complaint whilst you were acting as a judge in relation to what you dealt with in court.
That complaint had a number of factual inaccuracies. I'm not sure of the motive for the complaint, but the factual inaccuracies are dealt with in my response. It was not a case of two parties being there. It was a case of one party, the advocate representing the relevant municipality, asking to demolish a building that had been built by the owner, an indigent owner, in circumstances where there had been no personal service on the owner. And in my oversight role, as I said in my response, I was not going to grant a demolition order without knowing that the owner was aware that the application was before court. I had read the papers. I picked that up before the matter was called. It wasn't brought to my attention by the council involved. It ought to have been brought to my attention before I picked it up. But that council was very upset that they didn't get their demolition order.
Thank you, CJ. That will be all.
Thank you, JP. Premier?
Thank you very much. I think it's good afternoon.
Good afternoon, Premier.
CJ, I will start with a follow-up question because I had a presentation or a reflection that he believes in himself to be better and no one is better than himself. My question would be then from that one, what's your relationship with your colleagues at work when you believe that no one can match you, you are better than almost everyone?
Yes, the philosophy is in the context of being a human being, not necessarily in the context of the job. As a human being, I'm no better than any other human being, and no other human being is better than me. My relationship with my colleagues is excellent. I've always had an excellent collegial relationship with everybody that I work with.
No, thank you, CJ. I will save the second question, the question, because it was related to the presentation.
Thank you, Premier. Any questions for Commissioner Mtweni?
Good afternoon, Advocate.
Good afternoon, Commissioner.
Advocate, how do you perceive the role of technology in modernizing court processes? And what specific measures would you advocate for to enhance judicial efficiency?
I think that's an excellent question to ask a KZN advocate. And the reason why I say that is this. Although I'm a KZN advocate, I have done work in Gauteng. Gauteng has a system called case lines. It is brilliant. It saves trees because it gets rid of the need for paper all the time. So it's a green project. But not only that, it's just absolutely, it works in such a way that everybody who's a party to the litigation is kept up to date about every single thing that happens in that litigation the moment it happens. This is my impression anyway that I've had as a KZN advocate. Perhaps there are counsel from Gauteng who might not agree with me and might have had other experiences. But my experience in the cases that I've had there is that technology is technology that should be used in all of our courts. We, at the moment in KZN, we work with khaki-colored folders of documents. And sometimes you can be presented with a folder of documents that is 3 or 4 feet high, and you have an obligation to go through it. It's not properly paginated or indexed by the plaintiff's attorneys or the applicant's attorneys. You're trying to find out what the case is all about, why it's in your court in the first instance. I think the technology issue, the technology that Gauteng has, would be beneficial to all of the divisions. So I think that's a good question, and I support it 100%.
No, thank you very much. No further questions, CJ. Thanks.
Thank you, Commissioner. Commissioner Wyman?
Thank you, Chief Justice. Good afternoon, Advocate Whitman.
Good afternoon, Commissioner.
Just one question from my side. I get a sense that you take pride in your period of military conscription.
I beg your pardon that I did.
You take pride in your service under compulsory military conscription.
No, I don't take pride. I don't take any pride in it.
But how you took us through your DR, therefore, that's the impression that you created to me. So the question that I want to pose to you is, at that time, there was a structure called a conscription committee, which obviously was a conscious effort on the part of young white males who resisted the compulsory military conscription, which obviously I think create doubts in our mind as to your conscience at that time. You did not see it necessary. Didn't you see it necessary to join your fellow colleagues who were part and parcel of the end conscription campaign?
Thank you.
Well,
Thank you, Commissioner.
Before the candidate answers the question, I just want to place on record that I did not get any impression that he was deriving any joy from the account he was giving me. And all of us, he was just, I felt that he was just taking us through a life experience, matter of factly. But go ahead.
Thank you. I think I would like to answer it.
No, do answer it.
I was at university and a member of an SRC that was a left-wing SRC. And amongst the institutions that we had contact with was the End Conscription campaign. I tried to stretch my university degree out as long as I could to avoid military service. Personally, I was an opponent of apartheid and did not want to do military service. Eventually, I couldn't stretch it out any longer, and the choices for me were to peacefully object and get, as I recall at the time, a 6-year jail sentence, or go and do it and get it over with. I wasn't brave enough to take the jail sentence, and I'm sorry about that till today, but I wasn't. And I went and did service and got it over with. I was not in active service. I did my basic training in Pretoria at Fort Rekohoogte. At the time I was there were riots somewhere in South Africa, and they came to our bungalow and asked for volunteers to go and help quell riots. Myself and other left-wing members who had been at university with me refused to take part. We refused to go with the rest of them to quell these riots. We sat there. We were treated like rubbish from that moment onwards. That was the best we could do. It was a difficult time with difficult decisions.
No, thank you. I appreciate the fact that we are part of NUSA's activities. Thank you, CJ. Thank you, Advocate Pittman.
Thank you, Commissioner Muimangu. Commissioner Jozitube.
Advocate Pittman, 2 of the objections have already been put to you.
Yes.
But there is one that has not been put by Dr. Ghani.
Yes.
Who says that she was once your client.
It's a man, yes.
He was once a client, yes. And then appeared in another case now as a litigant before you. But you failed to disclose that fact and to recuse yourself.
Yes. That's what he says.
Yes.
So
I don't know if it has been brought to your attention.
Yes.
Oh, yes. All right.
I did respond to it. I did respond to it.
Yeah. No, we've got your response. Just answer for the benefit of everyone.
Do you want me to say anything more about it?
Yes, that's the objection. So it says we must ask you about whether you're suitable for judicial appointment, given that this was your client, they appear before you, you don't disclose, you don't recuse. Yeah. I mean, obviously you found against him.
No.
Oh, you didn't? Okay, well, still there was a duty of recusal. But anyway, what do you say?
So, thank you, Commissioner. So, he says in the complaint that he was my client in 2018. I can't remember that he was my client in 2018. But what happened was that I was the motion court judge on a particular day when a matter came before me as an urgent matter of and the names were G.S. Gani and I.S. Gani or something like that. I was not asked to make any decisions in that matter. It didn't occur to me that this might have been a client of mine. There are many Ganis in Durban, and I made no connection on one level or another. I was not asked to make a decision. They were both represented by senior counsel, or at least one was by senior counsel. One might not have been by senior counsel, but by a senior advocate. And a consent order was given to me, which I then made an order by consent. So I wasn't asked to make a judicial finding or determination one way or another. I was simply asked to record an agreed consent order and adjourn the matter. If I had known that he was my client previously, if someone had told me that, I would have, even in the face of a consent order, I would have said to them, are you comfortable with me making this consent order? I would have said to both parties.
Yes. But I mean, the point is, it's not really the nature of the order. The real answer is, well, I'd forgotten if he had been a client. Because if he had been a client, the duty would have arisen anyway.
Maybe. And I say maybe, Commissioner, because as an advocate, the independence of advocates allows you to represent a party in one way on one day and in another way on another day, as long as the matters aren't related, as I understand it.
Yes,
but you're right about one thing. I didn't know. If I'd known that they were parties, I would have certainly investigated whether there was a reason through a connection between the two matters why I should not be involved.
Yes. Well, sometimes, you ask a small question and then it gets bigger because of the answers. I thought this was a small question, so I would really like us to close it. The fact is you were not aware that this was your ex-client.
No.
You're not making any arguments about whether there was a duty of disclosure.
No.
Yes. All right. Thank you.
Thank you.
Commissioner Trollip.
Thank you, Chief Justice. Advocate Pittman, just for the record, and I'll be using the record later, was your late father Christopher Pittman's brother?
Yes.
Okay.
My late father was Harry Pittman.
Okay.
Christopher Pittman was always known by all of us as Kit.
Kit, right. When I read the papers, your application, your questionnaire, listened to the JP talking about your virtues, and I read your responses to the complaints, I find it very difficult to reconcile even the people that had nominated you, where, one of them said that you were generous and honest to the core. I found it very difficult to reconcile the allegations that were made by the complainants, and you did respond comprehensively. What do you think the genesis of those complaints were? Were they malicious or?
Are you talking about the demolition, the AFT complaint? Are you talking about the complaints that AFT raised in their... Right. Well, what do I think are the genesis? It's a very difficult question to answer because I really actually have no idea.
You have to speculate now.
I beg your pardon, Chief CJ? I'm sorry?
Do you want to speculate?
No, I don't really want to speculate.
Then maybe we should not waste time doing that. You don't know.
I have no idea.
Yeah.
But what I can say is that as an advocate, what I've realized as a judge since I've been acting, and lots of people don't really get this, our system of justice is an inquisitorial system of justice, not an acquisitorial system of justice. In other words, there are two teams that compete against each other in court, and a judge is a referee. Just like you get your referees in football matches, and you get your referees in rugby matches. And unfortunately, the way our inquisitorial system works is that there's often a loser. And when you are a referee, sometimes you simply get blamed. It can happen. I've seen it happen. I don't know. I'm not speculating about this case, but it is a possibility.
Have you finished, Commissioner Trollip?
Thank you, Chief Justice.
Do we have questions from the virtual platform?
Yes, Chief Justice.
Please put your questions, Prof.
Good evening, Advocate Pittman.
Good evening, Commissioner.
I think the story that you have narrated is commendable. The one that you spoke about trying to assist advocates from unfortunate circumstances for them to be able to afford their chambers. And I just want to build on that. We have learned, at least today, that there are still very much challenges with respect to the briefing patterns in KwaZulu-Natal, and the black females in particular seems to be, they are definitely at the floor of the briefing line. What role, if any, have you played in ensuring that, at least in your practice, because you are not the one giving out work, you cannot blame you for giving out work. In your own practice, what role have you played in ensuring that at least you rope in some of those people from difficult circumstances for them to be able to at least get some head start in their practices? Thank you, CJ.
Thank you, Commissioner. The nursery chambers is one way that we have I've managed to cut down costs so that they can make ends meet. As I refer to in my application somewhere, and it pains me to have to repeat it, I paid for a particular advocate's chambers for 3 months because they were not being paid by the state attorney. I have an open door policy. Every junior in my group trails in and out of my chambers all day, every day, because I'm trying to help. I use the juniors from previously disadvantaged circumstances, particularly those that I am aware of who are battling financially, because I administer the group of advocates I work in, and I'm aware of the financial difficulties some of them are faced with because they come and tell me. I use them to devil for me and pay them from the fee I get from the attorney. Those are the kinds of things that I am involved in to try and ameliorate the difficulties that struggling juniors are faced with on a daily basis.
That is commendable. When you do rope them in, do you rely on them in terms of the work that needs to be done? Because there is also that part of the transformation in making sure that they learn in the process.
Yes, most definitely.
No, thank you very much, CJ.
Thank you.
Thank you, Prof. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Advocate Pittman.
Good afternoon, Commissioner.
I just want to follow up on your answer to the question from Professor Marumahai. Did you bring any juniors into your matters as juniors, not as devils?
Yes, I have. But I'm very rarely briefed on the basis that I'm entitled to bring in a junior. So on the occasions that I have, I've paid for it out of my pocket. What I can tell you, though, is that as a judge, I've had a much better opportunity to provide not only the imparting of skills, but some financial relief to previously disadvantaged people in respect of the criminal work that I do. Our criminal procedure provides for assessors. I'm very comfortable doing criminal work. I could do a case without an assessor, but the purpose of assessors is important. One, because by its very nature, it allows for the input of a multicultural approach, so to speak, if you use assessors who are not necessarily lawyers or who are lawyers but are from different cultures. But the second thing is, I have so far done criminal sessions where I've used 2 assessors. I approached the bar for struggling black women who would be able to get experience in a full-blown criminal trial that they might not get anywhere else, and at the same time earn the assessor's fee. Those who I've used. And if I use assessors in the future, those who are the people that I'm going to use.
Advocate Pittman, my question was about juniors that you work with and not assessors that you helped get appointed. Do I understand your answer to be that your practice didn't permit you to bring juniors onto your matters?
No, sometimes, no. Ordinarily, what happens is an attorney will brief me to do something. I will say, can I bring a junior in to help me? They'll say, no, we haven't got fees for that. I then have still brought juniors in, but then I pay for that myself, which I've done. But it's not always possible. And the assessors that I use are juniors. I use juniors as assessors.
I think let's leave the question of assessors aside. I'm interested in the fact that you indicate that not all of your matters are worthy of bringing in juniors. It's not sufficiently big to bring in juniors.
Now, my practice is very big, but the nature of the case will demand whether the attorney will permit you to bring in a junior. And the nature of the client that the attorney has will decide whether the attorney gives you an instruction to bring in a junior. As counsel, you act on instructions from attorneys. You don't tell an attorney that his client must pay for a junior. You can advise it, and I often do. But that's how the relationship between attorneys and advocates work, as you probably know.
I'm slightly familiar with the concept.
Yes. So
Only slightly.
So there are cases where I think I need a junior, and if the attorney won't give me one, I use one of the juniors and pay myself. There are other cases which do not require a junior, and then I won't have a junior.
You see, Advocate Pittman, you've portrayed yourself as a proponent for transformation, but you've indicated now that your matters didn't always require the use of a junior.
Yes.
I just want to then get onto the second issue, which is your conscientious objection to taking silk, or to applying for silk, rather.
Yes. All right.
Has it ever occurred to you that you may be able to bring in more juniors if you apply for silk?
All right. It's not a conscientious objection to taking silk. And I'm going to refer to my family background again. I grew up in a family which held that status and title was irrelevant to the qualities of a human being. Now, that had an effect on my personality. So I started as an advocate, and up until this point in time, I feel personally fulfilled in what I'm doing. I haven't felt the need to apply for silk. Yes, your question is a very good one. If I take silk, I may very well then be limiting myself to the kinds of cases where a junior will be necessary. And in view of the development of the institution of silk, more specifically recently, with solid criteria being laid out for how you get there, I am thinking about that. If I don't get the job as a judge, that's probably the route that I will take.
Thank you, Chief Justice.
Do you have questions, Commissioner Bredenbach? Commissioner Mangeni?
Thank you, Chief Justice.
Yes?
I don't have any, thank you.
Oh, thank you. I thought we'd lost you. Commissioner Mangeni?
I'm covered, CJ.
All right. All right. You are excused with thanks, Mr.
Thank you very much.
Pittman. We
Thank
have
you very much,
finished the
CJ.
interview.
Thank you, Commissioner.
Recording in progress.
Is the Premier here, JB?
He is here, but he just stepped outside. Mintu? I'll ask the Secretariat to just nudge him.
Okay. Just bear with us a little while, Ms. Singh. There he is. Good evening, Ms. Singh.
Good evening, CJ.
We must apologize for having kept you for so long, but these things happen.
It's all part of the course, I suppose,
Yes,
CJ.
yes, so I know it's not a pleasant experience. You hail from Devon.
That is correct, CJ.
And you obtained your legal qualifications there.
I did, CJ, yes.
A BSOCSI from the University of Natal.
That is correct, as it then was known, yes.
Yes. And then you did your LLB at the University of Devon, Westville.
Also, as it then was known, CJ.
Yeah. You spent some time, well, a brief spell at the Lawyers for Human Rights directly thereafter.
No, CJ, I actually didn't. In my CV, I mentioned that I did some work for Lawyers for Human Rights, briefed by them, but not...
all right. Okay. It's a bit misleading. But then in 1996, you joined the KwaZulu-Natal Society of Advocates.
That is so, after completing my pupillage, yes, CJ.
All right. I assumed that you do, well, never mind what I assumed, it's irrelevant. So you joined the bar in 1996 and you've practiced as an advocate to date?
That is correct, CJ.
That's 28 years.
Going on to 28 years,
Almost 28
yes.
years, yes. What kind of a practice have you conducted in this almost 30 years?
CJ, coming straight from university, when I commenced practice, I was willing to take on matters to give me courtroom experience. So I started doing criminal matters, legal aid matters. I did high court pro deo cases. I was then fortunate to have been able to join Advocates Group 7. And there were many senior, junior advocates who passed on work to me, bearing in mind that I didn't know any attorneys to brief me when I started practice. So these pass-on briefs helped me forge relationships with attorneys, do the work to the best of my ability, and thereafter I was in turn able to obtain or be briefed by these attorneys. My practice started with a lot of matrimonial and family law work. It then moved on to doing matters in the areas of law of succession, trusts. As I became more senior, I developed a trial practice with matrimonial work, with personal injury matters. Yes, so that's been more or less my practice, CJ, a very broad-based practice, if I may describe it as that.
You also mentioned insolvency and property law matters in your...
Some insolvency and some property law matters, yes.
All right. You mentioned that you've also lectured to paralegals at the Community Rural Development Center.
Yes, I did, CJ. I did for a brief period of time. It was on a voluntary basis where I would go on weekends and lecture to paralegals more in the area of family law, maintenance matters. There was also a time when there were problems with applications for social grant matters, and paralegals would needed advice and to be trained on how to go into the community and assist the community with those types of issues.
Yes. You've acted as a judge intermittently between 2004 and now.
Yes, I have.
Having been in May.
Yes, CJ, I acted in 2004. I did a criminal session in Pietermaritzburg High Court, a criminal session. Thereafter, I began acting in 2023 again. As at the time I completed my application, I had acted until 31 May, but subsequent to that, I have done 2 further sessions, 1 criminal session and 1 civil session. So all in all, CJ, I've got about 43 weeks of acting.
23?
43.
43, oh,
yes.
All right. And you've written judgments during this acting stance?
I have, CJ, yes. On a rough tally, about 35 written judgments, excluding extempore judgments.
All right. Have any of those judgments been reported?
No, they've been published, CJ.
Okay. Any judgments reported in matters in which you participate as counsel?
Yes, and I think I've made mention of it in my application, CJ.
It's late in the day, my spirits are flagging, so you'll forgive me if I'm slow.
Certainly, CJ.
Well, if I feel like that, it must be worse for you. All right, I'm going to hand over to JP for your words.
Thank you, CJ.
Thank you, CJ. Good evening, Advocate Singh.
Good evening, JP.
I think you might get a benefit because it's late in the day, and try to be short because I am tired. By this time, almost all courts in the country have adjourned.
Yes, yes.
How were your acting stints?
JP, I enjoyed all my acting stints tremendously. Initially, where I had doubt, I was thrown into the deep end in the January-February session last year of motion court in Durban on a busy Monday morning, and it was then that I realized that all the years of practical experience came to assist me. And I must say, where I did encounter any difficulties, I must thank the KZN division, because every single sitting judge was more than, including you, JP, were more than willing to assist me with any queries I had. So it's been smooth all in all.
And compared to the one you had in 2004, how I don't want you to criticize it, obviously. I just want to see the atmosphere, because in 2004, we were still lagging behind in terms of diversity, maybe.
Yes, JP, in 2004, we didn't have our morning teas and our judges' lunches, which we now have, and which we now have the opportunity to discuss matters of relevance. I know there's the introduction during our Thursday judges' lunch, where one of the senior judges will discuss areas of interest or matters of concern in the division. In fact, there were no teas and lunches in 2004.
Yes. And I must commend you for hard work.
Thank you, JP.
I've sat with you on appeals, full bench and full court. In most instances, particularly where I sat with you, and obviously I benefited, you had prepared a draft for most of the matters that we sat in.
Well, Judge President, there may be something to be said about the more the merrier, because I adopted the attitude in my acting stints. The more I did, the more beneficial in terms of experience for me.
Yes. And I recall when you started acting, you almost had a conflict with some court staff because of the Lekedia style that they do things relaxed, and you wanted things sharp. And I had to remind you that this is government, not private practice, and it might be taken in another way, but not to allow them to be like that, but just for you to understand.
Yes, JP, I'm actually very grateful for that lesson, because apart from just getting the experience of acting as a judge, there are many life experiences that one learns. Having come from private practice, maybe I was used to doing things in my style, if I may put it that way, and I've had to learn to deal with diverse personalities being on the bench. So yes, I'm grateful, and I've definitely learned something from that.
And you have embraced our diversity to the extent that I think they have given you a clean name. What is it?
Amahadebe.
Yes.
And I proudly accept it too.
Yes. The fee dispute committee that you are involved in, obviously that allows you to, makes you to know how to make unpopular decisions. But how does it work, and what type of things that you adjudicate?
Generally, JP, it's in terms of the GCB and Society of Advocates rules, and our power is very limited to determining the reasonableness of council's fees. As a committee, we do not involve ourselves in other disputes which may arise, but really it's the reasonableness of council's fees.
Yes. And have you mentored any juniors in the past 28 years?
I have had 4 pupils, all black pupils, 2 of whom were female. Aside from that, I've had in the groups that I belonged to, junior members where I would always offer my service to them. I would pass on work to them. And as my practice has developed, where I've become more senior, and certain briefs do not require that level of seniority, I very readily refer my attorneys to counsel who are junior, but it goes a little more than just referring the attorneys to counsel who are more junior. I actively then check up on these juniors if they have drafts of pleadings. I check up on that. I actively assist them in preparing for court where necessary.
Yes. And the reserve judgments, what is the longest that you have reserved a judgment for?
I think it would be 5 or 6 weeks, JP. I've had reserve judgments from 1 day, where I've reserved it for a day, or otherwise 5 or 6 weeks, but not longer than that.
Yes, and I remember that at the beginning of one of the sessions, you were given a very huge matter, but you did not squeal, but just dealt with the matter.
Yes, JP, that was an opposed motion where it involved almost 9 opposed applications, and it was set down for 2 days. I'm happy to say I finished it within 1 day, and I delivered my judgment within 3 weeks.
Yes, and how many volumes was it?
9 volumes.
Yes.
Yes.
And you've conferred with colleagues when you had doubt on any issue.
Yes, and that is why I'm so grateful to the sitting judges of our division who have always readily assisted me.
Yes. And maybe finally, what are the greatest attributes that you will bring to the bench?
Firstly, I would say, JP, it would be my years of practical experience. I've got a very good work ethic. I'm not somebody to rest until I've gotten something done. So yes, it would be my very good work ethic. I'm a person of integrity. I'm also a very collegial person. I find it very easy to get along with people. And if I may say this, JP, I was part of one group of advocates for 18 years. And we have different personalities, but until we dissolved, for various reasons, people moving out to other buildings, I was part of that group for 18 years. Presently, I'm part of the group of Advocates Group 7 for 2 years, and before that, I was a member of Advocates Group 7 for 5 years. So I generally get on well with people, and I think that would contribute to our division working in a more united way.
Thank you, CJ. That will be all from me.
Thank you, JP.
Thank you, JP. Premier?
Thank you, CJ. I must say I'm impressed with the energy that Advocate Singh has at this time of the day.
Thank you, Premier. I think it is years of hard work and working till late in the evening that has kept my spirits up over the years.
Yeah, no, it's just one question. What's your view on the delayed judgments, and what do you think could be your contribution when you are offered the position to turn around as such, where you will be actually be employed?
Thank you, Premier, for the question. Delayed judgments, unless they are unduly delayed, sometimes it is understandable, the pressures of work for judges in our division. I know it's a very busy division, but it's also not excusable. There really has to be a cut-off time, because part of the reason, and I know this from years of being in practice, people come to court wanting their day in court, but also wanting finality on their matters. As to what I can do to lessen reserve judgments is, as I get more senior, I'd be willing to offer advice to more junior judges, to acting judges, almost like how the bar has been for years, an open door policy. So that would be what I would be able to offer.
Thank you, Chief Justice.
Thank you, Premier. Do we have questions from the virtual platform?
Thank you very much, CJ. I do have one question. Good evening, Advocate.
Good evening, Commissioner.
I see in your questionnaire that your practice at least is constituted about 25% of family law and divorce law. Is this something that you are quite familiar with?
Family law and divorce law, yes, I've practiced a fair amount of it.
All right. I have a question. Currently in practice, there's a serious problem, and I just want to get your thoughts on it. We see more and more members of pension funds resigning from their pension funds before a divorce can be granted. And we see more and more of these decisions coming in. I'm not sure, one, are you aware of this issue that is currently going on in practice? And how do you think this issue can be resolved to ensure that the other spouses are not prejudiced in terms of the claims that they may have on the pension fund of the member of the pension fund?
Thank you for the question, Commissioner. I think that is a very difficult one to say because one finds that in matrimonial matters, parties sometimes become bitter and antagonistic towards one another. And unfortunately, the only way for this type of issue to be resolved is for spouses to be familiar with one another's financial affairs. And should there be divorce proceedings, the spouse who is a non-member must perhaps take all steps to timeously advise his or her attorney that they suspect that there will be a resignation, and then the necessary steps in terms of court proceedings must be brought for this.
Let me this is not something that you have came across in practice, right?
I have come across it. Yes, Commissioner, I have. Generally, it was approached on the basis that an interdict is sought against the pension fund, obviously with the member of the pension fund being cited as a respondent.
Oh, okay. No, Chief Justice, let me leave it there. Thank you very much.
Thank you, Commissioner.
Thank you, Prof. It does not. Oh, there is another hand. Commissioner Elikhanyan.
Thanks very much, CJ. Good afternoon, Advocate Singh.
Good afternoon, Commissioner.
I want to start by saying that we cannot confidently say that we have achieved with regard to the affirmation of women in this country, particularly in the judiciary and other sectors. If you were to be appointed, what becomes your commitment to lifting up the spirit and supporting other women, particularly those who belong to previously marginalized communities?
Should I be appointed, then I am aware that the Office of the Chief Justice, or SAJ, runs various mentoring programs, various training programs, such as the Aspirant Judges Program. If I am called upon, and if in any way I can assist in that sort of training, then I will be more than willing to do so, Commissioner.
Thank you. There are no further questions for you, Ms. Singh. Thank you very much for making yourself available.
Thank you, Chief Justice. Thank you, and thank you to all the commissioners. Thank you.
You're excused.
Thank you.
May I ask non-JS members to clear the room so that we may deliberate?